Nope. Okay. Now, we also have Jessica Willoughby from the Department of Law, and Dennis Wheeler, municipal prosecutor, is here, as well as the municipal attorney, deputy municipal attorney, and chief of police. But Ms. Bronga, we'll go ahead and let you start.
Okay, and I'd also like to add, I believe that Anchorage School District administration is listening in, at least they were planning to, and I saw that Chief Case was in the house, so he'll probably be coming in shortly. So one of my first, oh, he is over there? Okay. One of my first, when people ask me, what do you want to do on the assembly? Supportive schools, safety, those were the two things that came to mind. And little did I know, as a civilian person not involved in politics, how difficult the state has made it for us to make our schools safer. Any of you that don't know what it feels like to do a active shooter drill with a kindergartner and tell them that if someone comes in with a weapon, throw tempera paint cans, maybe stab with scissors, it's ridiculous, scary. They go home not wanting to go to school. So fast forward, I had done nothing to try to do safe storage because I'm told we can't do that. And our fabulous and talented lawyer, Mr. Hurt, I talked with him, and he has found what he believes is a pathway forward. And I also had encouragement from our school board member, Carl Jacobs, who contacted me and said, is there anything the assembly could do? So I'll scoot right to the next page. Some of the facts that I didn't know till I started digging into, that 90% of the shooters in a school shooting are current or former students. 75% of the school shooters obtain their weapons from their home. In 2023, 5.6% of Alaska students and 3.5% of Anchorage students reported having carried a weapon to school on at least one of the 30 previous days. As of 2022, Alaska has the fourth highest firearm child mortality rate among all 50 states. And from 2018 to 22, firearms were the leading cause of death for children 1 to 17 in Alaska. So I believe that is the why this ordinance is needed. So this is what the state says, and the authority to regulate firearms and knives have been reserved to the state, which is the awkward position we are in. And I know that Ms. Willoughby has explained that the state's law is we cannot be stricter than what they call for. And so this just talks about what is out there currently. Maybe Member Hurt, or Mr. Hurt, could you just explain where this come into play? And
certainly. So as you stated, there are several statutes at the state level that are essentially preempting the municipality from enacting regulations beyond what the state has already enacted. It does make several carve-outs for us to enact identical regulations. I believe the site is on 2935, 145. However, there is a theory of prosecution known as principal liability, which the second site there discusses, which says that someone can be prosecuted as a principal, i.e. they can be prosecuted as if they had committed a crime themselves, if that liability is established in the elements of the offense. And so that is sort of the theory underlying this AO 2525. Was that sufficient?
Yeah,
Okay.
That's it. Whenever he gave me a cheat sheet to use about this, because principal liability is something that is legal speak is not my thing. But anyway, Thank you much. The next, under Alaska state law, a person 16 years of age or older may possess a firearm. A person 16 years of age must have the consent of a parent or guardian. And then there's the 21 or years of age or older for a concealed handgun permit. Then there are, in the small print, the exceptions, which is a private K through 12 in the parking lot of a school grounds, on a school grounds, at a school function, on a bus, any place where there's intoxicating liquor, or daycare center, or the courtroom, which comes in, I think, Chief Case talked about how sometimes they find weapons in the bushes outside the courtroom because they can't bring them in. So we have a lot of guns in our community. In the guns in the home thing, I don't care. I have guns in my home. You probably have guns in your home. Many of us have guns. Alaska is a state with a lot of weapons. And I want to say, when I had presented at Community Council, I don't care if you have them or not. I just want to make sure that they don't come to school. So 4.6 million children nationwide, 12,380 Alaskan children are living in homes with unsecured firearms. And 44% of gun owners keep firearms secured in the home. This ordinance does not require you to securely store your firearm. It simply says if it comes to school, you will be the principal liability on this if you did not in some way try to prevent it, make sure that the weapon was not in the hands of them. So that's one thing to keep in mind. I put on the Alaska Gun Rights Facebook page, which was probably a mistake, that what we're saying is have a stern talk with your kid. What we're saying is maybe you need to check his backpack or her backpack. Maybe you need to store it safely, but be a parent is what we're asking for. In 2002, the Journal of Trauma, Injury, Infection, and Critical Care. Now, this is kind of old, but what I found, it was very interesting because even though we could say that guns protect people, what we know is if you're keeping a gun in your home for protection, your business, you're 16 times as likely to die from an unintentional injury from the firearm, 7 times as likely to die from firearm suicide, the children that are in those homes, 3 times as likely to die from a firearm homicide, and twice as likely to die from suicide and homicide. So that's the stats. If you have a gun in your home for protection, it's pretty clear that if you have children in that home also, there is a great risk that comes with that. The comment that I often hear is it's self-defense. I need that gun for self-defense. I've had several people come up to me at community council meetings and tell me that. But for every time that a weapon has been used in self-defense, there were 4 unintentional shootings, 7 criminal assaults or homicides, and 11 attempted or completed suicides. So and then on top of that, the difference, this little part here with the less than 1%, if you took no action, there's a less than 1% difference than if you got out your firearm to protect yourself from someone who enters your home. Safe storage is an easy way. There's a little video here. I'm not going to make you sit through it. You all know. Safe storage saves lives. This does not call for you to do it, but if that's what keeps the gun from coming to school, that is an easy way. So Anchorage School District has reached the line of what they can do. In 2022, they partnered with the Be Smart campaign. They passed out all kinds of information to the homes about safe storage. They offered trigger locks. Another thing that can keep down school shootings is if there is an online platform or an app that helps to let people anonymously inform about spotting a weapon. And so Stop It text platform was started so that they could anonymously report harassment or weapon sightings. And then we've got these mobile metal detectors, which are going on a rotating basis to different schools. They have done their part to try to help with this. They also have a strict policy against possession or use of weapons or designed to look alike weapons, and that the list of weapons that are included: firearms, pellet guns, stun guns, shockers, knives, clubs, metal knuckles, and nunchucks, and throwing weapons like stars. Students possessing weapons are subject to disciplinary action, including expulsion. And this is a chart of the weapons, suspensions by everything. And then on the right is the weapons and firearms suspensions. And the farthest column is the 23-24. This year, the 24 guns were confiscated. And then it was I think it was 68 weapons suspensions. And that mirrored this year as well. And I don't think that's accurate, and I can't prove it. I mean, I know it's accurate how many were actually intercepted, but I know that there are other weapons coming to school that are not spotted. And so, and even if it's 4, if it's 5, if it's 10, like in 22, 23, it's still terrifying if you are a parent who has children in the school. One of the recent emails we got from Jonna Cole was about a lockdown at East High recently, that there was this terrifying, my kids are at this school, I don't know what's happening, are they going to be safe? And so, one is too many. So the next page, this describes what we're trying to do with AMC 0.25.060. It makes no distinction between accessory before the fact and principal. And so if the firearm or deadly weapon comes to the school ground or on a bus or a school-sponsored event, we are saying that if the parent made no effort to prevent that from happening, they will be charged as a principal in this. Is that right, Mr.?
I don't want to say a mild correction. The standard that it's using is criminal negligence, which is a question of fact for a jury to find whether or not the weapon was stored with criminal negligence. So either if a parent provided it to them, obviously knowing or with the intent of them bringing it to them, that I would argue is already chargeable under principal liability without even amending our code right now. The change that this makes is that it introduces the criminally negligent standard, which would require a jury or in a judge alone case, a judge to determine that whatever the circumstances under which the weapon was stored, it was stored in a criminally negligent manner.
Thank you for clarifying that. And then, so what this won't do, it's not going to take away your rights to own a gun. It won't take away the right for your 16-year-old to own a weapon. This will not force you to store your gun in a safe or lock your weapon. This will not invite government into your home. It makes the parent or guardian culpable for a violation by a minor child when the child brings a dangerous weapon to the school grounds. The parent will be prosecuted as a principal. So that, and Mr. Hurt just explained what in legal speak, what that means. So I'm sorry, I'm really bad at that. So anyway, I think as a final thing, I know this is a heavy lift. I really believe in my heart, without any legal training, that there is a window of opportunity to move forward, and we owe it to our children to at least explore this option, because we're not telling someone what they can or can't do with their weapons. We're just telling them, if this happens, this is what consequence there will be. And that's what I have.
First in the queue, Ms. Zolotow.
Thanks. I actually have a question for Mr. Wheeler and Chief Case. My main concern with both of these is, what evidence do we need to collect, and what are the likelihoods of prosecution being successful under both of these as written? So especially, on the failure to report theft, You know, I don't 100% know how this would play out. So kind of from the chief's perspective of like what evidence you would need to get. And then what does, you know, Dennis's office need in order to actually see this through for consequences? Because
Talking about the 28.
I'm talking about both.
Okay.
So these are two different offenses. And if we're going to amend criminal code, I want to make sure it works. I don't really have any problem with the intent of it. I just want to make sure functionally you all think it's going to work.
And I just wanted to quickly say that I haven't even talked about 2028 or 2528 yet. I can add some more to that, but I don't have a slick slideshow for that one. But I'm going to let them answer that question.
Through the chair, to the question on 2528, the elements that prosecution would be looking for and maybe the most difficult to obtain would be what started that 48-hour period. My expectation is that most of that evidence is going to have to be evidence that was provided by the defendant or somebody close to the defendant, either through some kind of admission or social media post or something like that. Because it's unlikely we're going to have any other way to know whether it was lost or stolen unless there's some admission that comes to our attention.
So I have a number of folks in the queue now.
Hold on.
Okay.
So is the time a problem, or is it what you have to prove that's the problem? Or is an interrelated kind of set of issues?
Through the chair, I don't know that the 48 hours is a problem in and of itself. The question is what's going to be the trigger? How are we going to have evidence of that trigger point?
And for the
And
chief,
is that evidence going to stand up in court and convince a jury beyond a reasonable doubt that the clock started on that, whatever that event might be?
and for the chief, like how would, right? Because usually things go from you to you. So how would you implement this? Or what would you expect to see or know?
Through the chair, members, I'll tell. So our standard is going to be a little bit less than the prosecution. We need the probable cause standard. So I would probably add to what Mr. Wheeler said, if we had family member or some credible witness that said the gun owner knew that the gun was missing 7 days ago and didn't report it until today, you know, we would use that as probable cause threshold to establish that timeline.
Then I have the same question for 25, you know, in terms of the principal idea. Is this workable? Can you enforce this? And is it prosecutable? I mean, these are, again, I want to make sure you believe that it functionally would work, or what you would need to make it functionally work. If the bar is so high, then I kind of just want to know.
Through the chair, and in one sense, this one is actually potentially easier to prove because you start with the notion that there's a weapon at school, right? So obviously it got there through some process that probably wasn't well managed. So you kind of work backwards from there in terms of your inquiry. How did this weapon happen to end up at school? And who's responsible for securing that weapon, and how was it secured, if it was secured at all?
I assume you want me to go as well? Okay. So this is a little bit longer of a process to investigate something like this, because we are going to probably get called presumably to the school. And as Mr. Wheeler said, we're going to have a gun that's there. That's the easy part. Now it's a conversation with the juvenile, and it's a conversation of backtracking to family, house, and how that weapon was secured. That gets a little bit more challenging. It's not as easy as just charging through someone's house and starting, you know, find those answers. So it's a little bit more challenging to come to the evidence to get it to prosecution. So I think Mr. Whelan are on opposite sides for each one of these. This one's a little harder for us.
Okay, and then my last question on this one, it says parent guardian culpable of violation by a minor child. Does it have to be that parent and guardian's minor child? So what if I did not secure my weapon in my home or in a home and it is in a visitor, right? The child is a visitor in a home for some other adult. I don't quite know here. Like here, when I read this parent or guardian of a minor, it seems like there has to be a familial relationship or a relationship between the two. So it doesn't take care of if an unsecured weapon from somebody else's home is taken. Is that a fair reading?
Through the chair, that's how I would read it, but I would defer to the sponsor on their intent.
The intent is familiar relationship. And if it's not written correctly,
Then it would be reasonable to assume if that minor took someone else's gun, then they would be chargeable under, not the person whose gun was stolen, but the child would be chargeable for theft, as well as all those other potential crimes. So it's an interesting distinction. Mr. Vaughn, then Mr. Rivera, and Mr. Salt, then Ms. Brawley.
Thank you, Mr. Chair. Okay. Maybe we go back to the Alaska state law slide number 4, I think it is. So, perfect. No, forward. Yeah. Boom. Perfect. Slide number 4 in the bottom right-hand corner. Yeah. Perfect. Thank you. So under Alaska law, a person who is 16 years of age or older may possess a firearm. And then under 16 years, they have to have the consent of a parent or guardian to possess the firearm. Was there any thought to making, because I think, unless I'm misunderstanding it, the ordinance would pertain to minors, so 18 and under. But if a 16-year-old has the legal right to possess a firearm, isn't it their responsibility to lock it up securely or sort of prevent it from being at school? Was there any thought to make 16 the cutoff rather than 18 the cutoff for the parent or guardian also being held potentially liable for criminal negligence?
thank you. We batted this around after you write something and then you go present, you go, oh yeah, that is. So at the senior center, some people that were in the presentation actually caught that. And I talked to Mr. Hurd about, we need to clear up what that is. And did you come up with?
Yeah, and that's largely a drafting error on my part, because if you look in the very first line where it says culpable for violation by a minor child, it's using minor and child interchangeably, which is incorrect in the code. The definition for child is a person under 16 years of age, and a definition of minor is a person under 18 years of age. So it would need to be revised to reflect one or the other, depending on the sponsor's intent. But yeah, I would say if that can be reconciled by changing the definition to child.
Okay, no, I appreciate that. I think certainly we want our schools to be safe. I think we also live in a state where 16-year-olds hunt and they have their gun in their truck. And so if they're legally able to possess the firearm and it's within their control, yeah, I suppose who bears the burden of making sure it doesn't make its way to school? All right, thanks.
Mr. Rivera. Hold on, Mr. Gates, do you have something?
I can speak in the nature of the queue.
Okay, Mr. Rivera.
Yeah, thanks. So a few questions and I'll just go through all of them and then appreciate responses. So first few questions are probably for administration or council. So first one, this is in relation to AO 2025-25. What does, this is on page 3 under C, what does stored the weapon in a manner reasonably expected to prevent unauthorized access mean? Is there some legal understanding of that. Second question, as it relates to AO 2025-28, same kind of thing. What does, or having reason to know, what does that mean in a legal standpoint? And then I guess for the, I'm assuming council did some research on this. And I asked this not because I think it should necessarily influence us in a huge way, but it would be helpful to know, have other jurisdictions looked at these types of legislation, and has this type of legislation gone through litigation? And I'm assuming you've done that level of research. Would love to know a little bit on that. So that's for administration and council. And then for the sponsor, I really appreciated the letter from the NAACP. There was a particular narrative in that letter, which I'm going to read, and the question is, how is that narrative in this letter reflected in the ordinance? So what this ordinance says is, what the letter, excuse me, says is, quote, "It does not mandate punitive measures, but instead encourages family to take proactive steps to prevent such incidents. This ordinance supports a culture of shared responsibility, something we believe is essential for community well-being and educational equity." That's all things that I support. How is that reflected in the ordinance? Questions can be taken in whatever order.
So I'll go first. So the first question you had was with regard to 3B, the owner failed to store the weapon in a manner that would reasonably be expected to prevent unauthorized access to the weapon. That language already exists in our code, and it's grafted over from state statute. Like, that is the standard that the state has dictated for returning the firearm to the owner. So again, I think it's not a question of fact for a jury in this case. It's really a question of fact for the chief of police, whether or not he finds that the weapon was stored in a reasonable manner. The known or should have known standard is essentially the mental state required for most general intent crimes, basically knowing, or if a reasonable person, using the reasonable person standard, apprised of all the facts that they were aware of. I mean, you can't plead ignorance when all evidence to the contrary would indicate otherwise. So it's the standard for most criminal conduct. So yeah, you may not have, I'm trying to think of a hypothetical situation here, but when there are enough facts that a reasonable person who was aware of them would have known that the weapon was lost or stolen, a person can't plead ignorance in that situation. And then what was the third legal question? Sorry. Oh, okay.
No, that was for the sponsor.
That's for the
The
sponsor.
third legal or admin question was around
Okay.
litigation. Yeah, other jurisdictions
Other
slash
jurisdictions.
litigation.
Okay, so there's within the state of Alaska, because of that preempting language in state statute, there's no case law at all revolving around something like this, and most municipalities don't have. I won't say most, but I will say very many municipalities don't have this kind of preemption language in their state statute. So this is novel. There is, I could find no analogous case.
Thank you. And I really appreciated NAACP's letter also. I don't know why I'm recording myself. But anyway, this new law, in my mind, the legal consequences would be the last resort, that this gets the conversation that this is a partnership between families and schools and parents and their kids. And it just asks for a larger partnership. And so the main goal of this is that you go, oh my gosh, they might bring it to school. I might have consequences. I think I will store it safely without telling anyone they have to do that. That would be my main goal. And so I do think it is bringing together parties for better discussion, and it's not meant to be punitive. For some reason, you have to throw the pew out there to get any recognition of what we need to do. I hope that answers your question.
Thanks, that does. Just final comment. Yeah, appreciate the legal responses. I guess what I would say, a piece of advice to Member Braga is that I appreciate that intent, but I don't really see that reflected anywhere. And so perhaps it may be appropriate to reflect that in the memo. So you may want to update the memos of both of these ordinances to better reflect your intent. Thank you.
Yeah, I was gonna come back at you and say, where did you see an answer to your question? Because I didn't see one. Thank you. That's Mr. Salt.
Thank you, Chair. A lot of mine's been covered, so agree on the intent that should be stated. I'm concerned about criminally neglect storage being kind of somewhat undefined. I can see a lot of ways that it would be stored properly and not properly. I think, remember Volan touched on it, someone goes hunting, puts the gun in the back of their car, goes to high school, forgets about it. That stuff happens all the time. Are they now, it's all under interpretation of what was the intent? And the last piece, I think probably a simple yes from Chief Case. Section B1, it says a police officer is acting outside the scope and authority. So I assume if you are acting within the scope and authority, you're authorized to carry a gun and so forth and so on. Pretty basic. Thanks.
Through the chair, Mr. Salt, yes, yeah, correct.
Okay, Ms. Brother.
Yeah, thank you. And I'm still kind of digesting these. I will note, it is an interesting question about kind of the parent being, or parent guardian being, culpable for what the child does. I'll just point to, there's a piece of the alcohol state statutes, which grant a different situation, but essentially it's about furnishing a minor. And normally that's a class A misdemeanor, but if the person who receives the alcoholic beverage, so in this case, a minor negligently causes serious physical injury or death of another person while under the influence of that beverage, and then they have definitions for that, the adult who furnished them is liable for a Class C felony. So I'm just pointing out, there is an interesting precedent or other piece of state statute that basically contemplates when an adult gives a minor something, which I know that that's a different situation than this, but I think it is interesting to point to. But my question is, and I think it's along lines of what Mr. Solt said. Basically, I'm looking at there's a difference between authorizing the minor to possess the weapon and presumably say, yeah, it's fine to take it to school versus storing it. And I just wonder if especially, I guess I wonder if there's a way to tighten this up or to consider, and this is more to the sponsor, I suppose, but would you consider a more kind of narrow definition, or to our, the police and prosecutor folks, do you think it's the storage part that's important, or is it the authorizing the weapon? But I also see why there'd be complications for both of those scenarios in terms of whether the parent was aware or had intent. Thanks.
I could just want to say, I really want storage as part of it. I feel like parental, handing it to them, giving it a weapon, is super important too. I wouldn't want to see the storage element go away. But as I said previously, there are different kids, and some kids, they're in ROTC, they've been trained to use guns safely, and they've had conversations about what can happen if you bring it to school. Their families are very different than other families. And so sometimes, this may just refresh the conversation that this is what can happen if they come to school, and I might be responsible too. So, I'm hoping that it can stay in that way, but I'd like to hear what legal has to say on it.
I haven't had an opportunity to confer with the Department of Law on this, but I think acting essentially as an accomplice before the fact is already covered under principal liability in our code. So a parent who gave a child a weapon with the intent or the knowledge that they were going to bring it to school anyway, I think is already prosecutable as a principal, as code is written right now. Similarly, if they have a child who has a history of violence or has communicated a threat to kill someone and they allow them to have a weapon, I think there's an argument that you can already prosecute them under existing code if they bring a weapon to school when a parent's been on notice that their child has expressed an intent to use a weapon and allowed them to keep a weapon. So I think the key distinction with this ordinance is that it is making the negligent, the criminally negligent storage of the weapon the nexus, as opposed to the actively giving it to the child.
Yeah, thanks. That's all.
All right, next I have myself in the queue. Can we go back to slide number 4? What state law requires individuals 21 years of age or younger to apply for a concealed handgun permit? There is no state law that requires that. So I just want to point out that I'm not sure what the basis of these slides are at this point. Mr. Gates.
If I'm remembering correctly, I think that statute was ruled unconstitutional by the Alaska Supreme Court, but it's still in the books, which is probably why it's here on the list. So it hasn't been repealed in the Alaska statute books.
I just know that the legislature eliminated all requirements for any form of carrying permit. And so I just don't know under what rule so it just raises lots of questions for me. It's not factually accurate. And so as to the intent language Mr. Rivera was speaking to, I believe it needs to be more substantive than the memo. If that is the intent, it should somewhere be in the document itself, the whereases, or even some of the effective language. If the intent is to not be used as the initial purpose of this is to be used as a legal hammer, or if it's to facilitate communication, those are two very different universes of things. But when a thing makes it into section 8 of our code, it is the hammer. And so if there is some other intent, it needs to be expressed. And I believe not simply in the memorandum, because if it's just in the memorandum, then that's yesterday's news. Someone might find it someday while doing some anthropological analysis of why we did what we did, but it's not going to have any effect on the law or the implementation of the law. And so I think that I would advise the folks who are sponsors of this to look really closely at that language, or let us really contemplate that the testimony we received from the NAACP was wishful thinking, not accurate to the law that's being proposed. So next I have Mr. Martinez.
Thank you, Chair. I just wanted to flag similarly the same concern with respect to the articulation of something other than what we have in front of us, right? So it was articulated that this is like a start of a conversation. Partnership was the word that was used. There's no part of this document that describes partnership to me from the actual letter of what we are considering. So just to be exceptionally clear, there's that framework is not what is being presented today. So if there needs to be additional work on that, then perhaps then the nexus point is about the criminalization aspect, or what was articulated was something else. And so I just wanted to flag that as well, Chair. I think that is, it didn't need to be articulated that there was something else off to the side. I still have a problem with the potential criminalization aspect, and I think there needs to be more work and discussion in that aspect. But if the sponsor's intent is different than criminalizing folks or potentially criminalizing folk, I don't see it in this particular item. Thank you.
Ms. Zalatow.
Appreciate the feedback.
Thanks. Yeah, so I'm in the same boat. Class A misdemeanor is 1 year in jail. Class B misdemeanor is 90 days in jail. I don't know if there's the opportunity to move this into a civil penalty realm where the price is enough to be a deterrent and start your conversation versus the potential of jail time. Also, a criminal conviction on someone's record has sometimes unintended consequences. So I have pause at that, and not saying that this isn't a serious problem that needs to, but if the intention is partnership and we want to start somewhere short of jail time, but if we set the expectation that this is in the code as misdemeanors that do have jail time, right, that's subject to some prosecutorial discretion. And I worry about discretion for such things where there might be different socioeconomic or other cultural standards in the home as to what it means to secure a weapon, what that conversation might be. I think there's a lot of potential for unintended consequences and disproportionate or disparate impacts based on things like socioeconomic status or race if we're not careful. And so I don't know if there's an option for just a civil penalty that is dollar-based with a not to exceed amount or something like that, but I would feel more comfortable there. And if that isn't doing it, then maybe we need to have the secondary conversation around criminal penalties. Thank you.
I just want to respond to that. I just, in my head, I'm looking at things like wildfires in our city parks and cutting of trees, and those are fines. Nothing happens with them. If a weapon comes to school and it gets to the point where we can see that the parent either provided them, I'm very certain that this would not even go to court unless it was very clear that there was some sort of, the kid says, my dad said, take this to school. You know, there was real evidence that this weapon was provided. That would be where there should be some criminal charges, I believe, not just a fine.
So that's not what these ordinances say, though. And so I think that that's what I want us to be really careful about. I understand your intention.
Yeah.
But these ordinances don't say that. These ordinances have elements, and if the prosecutor's office and if the police can find probable cause, then there can be an arrest. Then the prosecutor can prosecute them and meet the elements and secure a misdemeanor conviction, which can have jail time. So I think that has to always be at the forefront of what we're doing. It's been a practice for the 6 years I've been on the body that when we start touching the criminal code, we do so very gingerly and very carefully. So for me, I hope we can take a little bit more time. I think your intention is great. I think one of the questions I have for the school board is, do we have the demographic breakdown for the data that was provided about the offenses, students with disabilities, whether or not they were BIPOC. So I see we have a school board member, so I'm making that request because I really want to get a fulsome understanding of the issue. So that's where I'm at with it. So I just wanted to make that clear.
Did I get you in the queue, Mr. Okay, no, I probably got you and then just didn't write down. Mr. Gates.
Stay at the bottom of the queue. There. Okay. Thank you. I think, of course, the legislative intentions, like Salto said, are good. I only want to speak to the legal situation of preemption and whether we're legally authorized to pass these ordinances. I've expressed this opinion to Mr. Hurd. Ms. Bronga, I think all the members should understand that the preemption by state law is pretty broad. Ms. Bronga opened saying that she, I think, stated that Ms. Willoughby had said that we can be more restrictive than state statute, not less restrictive. That's not the preemption in knives. This applies to these laws, in my opinion, to firearms and knives regulation by municipalities. It's a different standard, a different preemption in knives. When a statute, like our traffic code and the state traffic statute says we can't be inconsistent with what the state law says, that's where that analysis applies. We can be more restrictive. But this is different because if you could pull up the slide, I think it's slide 3 in the state statute. This doesn't have the full quote of the state statute, but it says under that number 1, the first party is, it says in state statute 2935, 145, and except as specifically provided by statute and clearly enact enforce an ordinance regulating possession, ownership, sale, transfer, use, carrying, transportation, licensing, taxation, registration of firearms or knives. I think the word possession is applicable there. Mr. Hurd, of course, he's got, I think, a great theory, very good theory in terms of principal and accessory liability, and that sort of already exists, except here in subsection B of the state statute, it's got the 4 situations where municipalities can regulate, and it's, the discharge of firearms within the municipality, where they can be sold, that's our land use regulation, prohibiting the possession of restrictive access areas, but the first one is we can enact, municipalities may enact and enforce ordinances that are identical to state law and that have the same penalty as provided by state law. And I think that's where my issue is, and where I think that we have a little risk of these being overturned in court because these aren't identical to state law. We don't have, I think, stored in a criminally negligent manner, criminally negligent manner as an element of, I think, any of the weapons and firearms state statutes. And so these are not quite identical. We don't also have principal and excess liability language in these state statutes. So these ordinances aren't identical to that. And so that's where my main concern is, that you're probably not authorized to pass these, but I can't guarantee any court results or what a judge would say, if they would agree with me or agree with Mr. Hurt. And I don't litigate in court. That's the Department of Law's job. So I defer to them more when it comes to the likelihood of success.
Of course, sends the ball over to the Department of Law.
Through the chair, Jessica Willoughby, Assistant Municipal Attorney. I appreciate being here today. I actually didn't know about the Be Smart and Spot It tools at ASD. So as a parent, as a student at ASD, I appreciate that. But in terms of the analysis of the space that we have, and this space is, I think, different, like Dean was just saying, than the space that we operate in under other under issues and other areas of law. So I do think the state's language is very strong, and I think it would be helpful, and I don't love creating sound bites for future litigation adverse to the municipality, but if assembly members took a moment and read the specific language of the state statute, because as Dean said, it really is specific to our limitation to what the state has done, to mirror what the state has done. So if you look at these ordinances as an expansion of what is already on the books at the state level, yes, I do think they could be subject to legal challenge and potentially successful legal challenge. Dean, of course, is right. We can't, we don't have a crystal ball. To the extent that they're trying to send a message or encourage compliance in other ways, potentially, there would be room to take this ordinance and potentially do something else with it. I don't know, but in terms of getting creative with how to encourage safer decisions around firearms.
I appreciate, I feel like this song keeps coming to my head, "The cheese stands alone." It would have been easier to work with someone on this. And so, because I am one little brain, lots of other brains can be helpful. And that, I would love if we could workshop it and try to find a product that really says that the intent is to facilitate coordination. It's a really good point. The safe storage, or the report of lost or stolen within 48 hours. In my mind, federal firearm licensees, they're required under state law to report within 48 hours. And it just seems very bizarre to me that a firearm could be stolen from a home and you don't have to report in 48 hours. That to me, there's 23,000 stolen firearms a year. And I think Mr. Chief Case said 400 in Anchorage. Those stolen firearms are often involved in criminal activity. There is a reason to try to tighten up the expectation that if they're lost or stolen, we report. And the only reason, now, some people at community councils have said, well, who wouldn't report? Well, people who don't report shouldn't have the gun in the first place. So that's, kind of what it comes down to, or there's some other reason that they're trying to hide behind that. But yeah, I don't mind workshopping it. If anybody wants to help me to try to get it to be something else, I would love that.
So I am Mr. Gates, and I think Mr. Martinez in the queue, but I will say, I think, not Mr. Martinez. I think there is a long thread of American history of people who believe and would not comply with reporting a weapon in any universe. And so I don't know that we're breaking any ground, or that it is a reasonable expectation to think that people would report, even though it is the law or not. And so, because I know a lot of people out there who would say, you want me to do what with my gun? And yeah, so I just know that is the divide of this question nationally. Mr. Gates.
Oh, well, I was just going to sort of clarify when I said identical to state law and what it says in the statute. I think it's more about being substantively identical and not like word for word, textually identical. Just clarification.
So, but then with that caveat, is it your opinion then that these are substantially similar to the state laws or not?
Well, I think they're likely preempted by state law. And
Okay, so despite the notion of what the definition of identical or similar is, in your opinion, it still falls outside of that boundary. I do appreciate that
not substantially identical, but substantively.
Substantively, sorry.
Exactly. Yeah.
I don't know what the difference between substantially and substantively is, but yeah. I know that the municipal and deputy municipal attorney are sitting in the back quietly watching us all flounder on this question. And so I appreciate them being here, because they will ultimately be responsible for managing a response should this come to pass. And so are there other inputs? I think that if there's not, then it's an interesting exercise, and I look forward to seeing an amended version if there is one. And we will have this before us at a public hearing on the meeting of the 8th. And as I had told everybody, if we get a wave of people to come testify that starts to approximate a filibuster, then we will continue this item to the special meeting. The special meeting has been scheduled, just so you all know, for the evening of the 17th, which is Thursday. And the time at which we will schedule it will either be 5 or 6 p.m., depending on how many items from the meeting of the 8th gets. Yeah, I have a couple members lobbying for the 23rd to take up these items. So I appreciate that. But practically speaking, we have scheduled a meeting, but the time in which it will happen will depend on how many items from the meeting of the 8th have to be continued, because it is a packed agenda and some items just have to get done by the 22nd, but the 22nd is also not so small of an agenda. So for the purpose of good order and getting the work done, if this item gets to the point where it's hot topic and lots of people in the room, it may be postponed to that special meeting, or the request may be made to the members to postpone it to that special meeting. So
Like it was a joint choice.
yeah. So, well, there will be a choice, because the members are the rulers of the question before the body. So with that, then, thank you, everybody. Thank you for all your work on this. And we'll stand adjourned, and we'll be back together on Tuesday.